Mail your mail.
Okay, planning board. We are live. We are recording. Phone lines will remain off. Go for it.
Thank you very much. Good evening, and as I mute, there we go. Welcome to the Town of East Hampton Planning Board meeting for February 28th, 2024. We have three matters on for a work session, an artist studio review, and then two sub-waivers. Then we have a number of matters on for a regular meeting to take care of some business of scheduling future events. And after all that is done, we will we'll be moving, presumably, into executive session. There'll have to be a motion on that. So with that, we will begin with the Christina Schlesinger Artist Studio Review. Sharon's got that for the board. Tina, you're covering everything tonight for the planning department?
Yes, I am.
Okay, and is the applicant here?
Yes.
Very well. Okay, the way this works is first we're going to hear from the planning department, then you'll have an opportunity to speak, and then after you're done, then Sharon will lead us in our conversation about the application. So, Tina, go right ahead.
Thank you, Sam. I have on the screen the location of the application. It's at 16 Drive in Springs. I'll bring up the survey so you can see the property and the project. This application is made to construct an expansion to an existing artist studio. The property is currently improved with a one-story residence and an existing artist studio where this would be in addition to it. The planning board has reviewed this several times over the last few months. At the last meeting on November 20th, the board found the application was incomplete pending two items. The first was a survey depicting clearing and confirming that the property was in conformance with the town's clearing regulations. The survey has been submitted as requested, indicating that the property is in compliance with the clearing, and the numbers describing that are included in the report. The other item that was outstanding was an artist studio declaration. The applicant has submitted a draft of the artist studio declaration. The only element left needed is a legal description of the property. Once that's received, it will need review by the town attorney's office, and once they've approved it, it would be recorded with Suffolk County as a condition of the building permit, should the planning board choose to grant approval. So in previous discussions, the planning board has reviewed this application and determined that the items I discussed just now were the only ones outstanding. If they still agree with the project moving forward, we recommend that the application is complete and ready for a public hearing.
Very good. Thank you very much, Tina. Does the applicant wish to be heard? Nothing says you have to be, but you're welcome to be.
I don't really have anything to add. I mean, this is explained to me that I didn't realize.
You need to step up, say your name,
okay,
and then go.
My name's Christina Schlesinger, and I live in Springs, and I've been trying to create an extension of my studio so that I have more space for my work, and it's been a while. I'm trying to do everything correctly, and the only thing she explained to me was that I guess the thing that's outstanding is this legal description of the property, which I originally got my artist studio validation to build a studio in 2005, I think it was a while back. So I had to resubmit all that stuff, and apparently, which I did, but I guess I didn't do the legal definition. I didn't realize until the night that was also required. So I'm just trying to do the right thing, and so I can get my extension done. So I guess that's all I have to add. So is it been okay?
Once you sit down, and then we talk, and then you'll find out. Keep you on tenterhooks.
Yeah. Yes, it's okay. In my opinion. Yeah, no, it sounds like once you get that, it sounds like we can deem this complete tonight, schedule for a public hearing, and in the meantime, you can get that paperwork into us, and we'll go from there. So I'm okay with this. We've seen this application a couple of times, and we've decided that she's an artist, that she could use this space, and so let's move forward.
Very good. Okay, in that case, does anyone else have anything they want to add? Okay. So do we all agree that the application's complete and ready to be scheduled for a public hearing?
Yes.
Okay, that's part one. Now for part two. Sharon? Do you need the resolution?
Oh, you have it right there.
Let's read that in.
Okay, so we are going to schedule the public hearing right now. In the matter of the application of Christina Schlesinger, Artist Studio, tax map number 300-80-3-38. This is a resolution to schedule a public hearing for March 10th? Oh, March 20th, sorry. A public hearing will be here at Town Hall, 159 Pentago Road, East Hampton, on Wednesday, March 20th, 2024, at 6:30 PM. I move to approve this.
In a second?
Second.
All those in favor?
Aye.
Any opposed? At 7-0. Okay, the next thing you should do is talk to Tina or somebody over at the planning department and make sure, because this is very important, that you post and mail and do everything else to get the public hearing properly noticed and scheduled. What you don't want is to come back here on March 20th and find out you did it wrong and that we can't hold the public hearing. So
What do I need to do?
contact planning.
We'll
Yeah.
give you the instructions.
So they will guide you through, but just understand that you have to follow this very, very particularly because the law requires that there be a posting and another notice be given. So you're going to have to make sure you do it right.
You're basically notifying your neighbors.
Yes.
Yeah, right. Yes.
Yeah.
And then then presumably we'll see you back here on March 20th.
No, I hope so.
Very good.
Thank you, and I'll give you a phone morning.
Yeah, sounds good.
Thank you very much.
Thank you.
very much.
Thank you.
Okay, next application is sub-waiver review on McDonald Griffin. Ed, you got two on tonight.
I do.
Okay, and the applicant you've got that one? Very good, okay.
Okay, thank you. This is the application for the McDonald Griffin sub-waiver located at 981 Springs Fireplace Road in Springs. The application is made to subdivide an existing approximately 1.25 acre parcel having frontage on Springs Fireplace Road into two individual lots. The site is zoned B residence and is adjacent to, although not within, several environmental areas of consideration, including a scenic area of statewide significance and the Aconic Harbor critical environmental area, excuse me. The site is currently improved with a two-story single-family residence with a porch and patio, outdoor shower, and are all appear to be approved as per the recent CO. Regarding the issues for discussion of the memo, the action is unlisted pursuant to SECRA, so we recommend that the applicant prepare an EAF using the New York State Department of Environmental Conservation EAF mapper for review of the planning department and so the planning board can request lead agency status. Regarding lot size and zoning requirements, I'm going to bring up the survey showing the proposed subdivision. So there's two parcels that are proposed. You can see parcel 1 is in the frontage and parcel 2 would be a flagged lot. According to the planning department analysis, both parcels meet the dimensional requirements of the B residence zone, where the minimum lot area is 20,000 square feet. Parcel 1 would be approximately 29,000 square feet, and parcel 2 would be approximately 21,000 square feet, not including the access strip, which can't be included for lot area calculations in the subdivision. With respect to some things that need to be added to the map, we're suggesting that the building envelope just be shown as that is required for code. We would ask that the applicant also make a note that the dimensional, that the setbacks shown are only that which are required by the B zone and not due to any special environmental consideration. We're simply adding the ABS to the map because it's consistent with code. Regarding access from Springs Fireplace Road, the property is currently served by a circular driveway in the southern portion of what would be Lot 1. And there is no access plan shown for Lot 2. As the planning board knows, for subdivisions, the planning board typically requires common driveways to ensure that curb cuts to roadways are minimized. And for this application, we're suggesting that we do need a common driveway plan showing that, a established driveway that would serve both residences. In this case, what's shown here is that there's a circular driveway and that the back lot would, I guess, take access from a portion of that existing driveway. We'd like to see a common driveway plan submitted and designed according to town code requirements that are cited in the memo for the town engineer review. Such a plan would likely recommend the closure of this second access to Springs Fireplace Road just to reduce the amount of cuts. The status of this roadway, we did want the applicant to look into. Unclear whether or not this portion of Springs Fireplace Road is county road or town road, and whoever has jurisdiction of the road would need to be consulted regarding their approval if there's any changes to the curb cuts. Regarding site engineering design, I noted that we do need a common driveway plan, and that would include a profile that shows the design of the roadway as well as any drainage that's necessary. The next section of the memo is regarding the scenic easements and reserve area requirements. Pursuant to town code, subdivisions are required to provide a 10% scenic easement area or reserved area on the frontage of the property. This is proposed in order to maintain the rural character of the town and serve as a natural buffer from the proposed development. We know that this is an area of Springs Fireplace Road that does have an enhanced scenic quality, and we would want to make sure that that is preserved with this application. It's near a special historic landmark and Ecbonic Harbor. Therefore, we are recommending that a scenic easement be mapped on the property's frontage. There is an existing wooded area, which I'll just go back to the aerial imagery. There are natural wooded areas in front of the lot already, so we would suggest that we map scenic easement consistent with these areas, and that a revegetation plan more formally establishing vegetation in these areas be developed as part of the application. The scenic easement would need to allow for a driveway through it, of course, because we do need to access the property. Regarding clearing, the property does seem to be consistent with the town's clearing regulations. Currently, as built, Lot 1, and then obviously Lot 2 does not have any development on it currently. The next several sections of the memo just discuss sanitary systems. Obviously, an IA system would be required. So we put that in, when Lot 2 is developed, that would obviously need that type of facility. Suffolk County Department of Health Services approval is going to be required for the subdivisions, revising the applicant to start that process. The applicant did include a letter from the Springs Fire District Board of Commissioners, which indicates there's no additional fire protection needed here, so that has been taken care of. The fire marshal will still have to review the plan once the common driveway plan is available. They do closely review the access to the properties. In conclusion, the application is incomplete pending the submission of additional details regarding the lot dimensions, site access, and how the easement will be mapped on the property. And we do recommend that a common driveway plan is developed to serve both the lots. Thank you.
Thank you, Tina. Ms. McCaffrey?
Good evening, Shannon McCaffrey, Dewey's Planning. I represent the homeowners of 981 Springs Fireplace Road. We are proposing to subdivide this lot into two lots. Lot 1 is proposed to be 29,069 square feet, and Lot 2 is proposed to be 25,425 square feet. Both lots meet the minimum requirement of 20,000 square feet. The planning department estimate of the proposed lot widths are accurate, and we will have the map updated to clearly depict these numbers, as well include the building envelopes. These lots will be taking access from Springs Fireplace Road. The memo suggests that this property fronts along County Road 41. Ken Danzig of the Suffolk County Department of Public Works has confirmed that this property does not fall within the jurisdiction, as Road 41 runs from County Road 40 and terminates at the intersection of Woodbine Drive. We do accept the recommendation of a common driveway, and we'll have this designed by our engineer for the next submission. We also do not object to having a scenic easement, but we'll need to modify it from being a consistent 30 feet in depth in order to accommodate the existing IA septic system that's in the front yard. So, because we'll have to maintain a 5-foot setback from the proposed easement to meet health department standards. So we'll have to jog it. Do you mind zooming in maybe a little
Sure.
bit, Tina?
Hold on, yeah, system is too close to the easement.
Right, so
I see now.
30 feet puts us like about here, so we'll have to jog it towards the road.
Okay.
Just because we can't have our existing septic system
Right, okay.
in the easement area. And then next, the proposed building and septic system that is shown on Lot 2 is just a standard lot layout that is required for the health department review process. They're not proposed to be constructed at this time and will be removed from the map at the time of recording. We'd also like to note that all proposed and existing septic systems shown on the map are low nitrogen reducing septic systems. An application is pending review from the health department at this time, and we'll include the reference number in our next submission. And finally, we would like to note that the Suffolk County Water Authority does not review subdivisions unless a water main extension is proposed, and that will not be needed for this application. Please let me know if you have any other questions.
Thanks very much. Okay. Ed?
Yeah, thanks, Shannon, appreciate that. And thanks, Tina, for the description as well. Yeah, so, I mean, this is really a beautiful spot on Springs Fireplace Road, no question about it. And even though it is a B resident zone, I mean, most of the lots in this neighborhood are larger than that. So thank you for being, sensitive to that. And for accommodating us on the scenic easement piece. I mean, there is some natural vegetation already there for about maybe 20 feet or so. So thanks for adding the additional area, and yeah, jogging, as far as I'm concerned, jogging around the IA system is perfectly fine. And yes, thanks again for the common driveway thing. I think that is also really important to have one curb cut there. So yeah, are there currently no specific plans for a house at this point on the back property? Is that fair to say?
It's more for estate planning right now.
Okay.
So they want to get the subdivision done, no plans to actually construct at the time. I also forgot to note, if the planning board would like for the scenic easement, since we'll be closing off part of the driveway with the common driveway, we can submit a planting plan.
To continue to
continue that planting,
Right.
to connect from in front of the septic system to that area
Yep.
of the driveway.
Good, thanks. I actually have no other comments. Sounds good to me.
Anybody else?
No.
Nothing to
We'll
add.
move to the questions. All right, should the applicant confirm the proposed lot width for each of the two parcels proposed in this application? You got a yes on that? Yes. Okay. Must the applicant revise the map to depict the locations and setbacks to all building envelopes proposed with this application? And I think we've got a yes on that.
Yep.
Stop me if there's a no. Does the planning board agree that additional details should be provided pertaining to site access for each parcel proposed with this application?
Yes.
All good. Does the planning board agree that a common driveway should be provided to serve the residential subdivision?
Oh, yes.
Good yes. If the planning board agrees to a common driveway should be provided, should the applicant submit a common driveway plan that shows all pertinent design details?
Yes.
Should the subdivision include mapping of a scenic easement or similar mechanism to provide the frontage along Springs Fireplace Road?
Yes.
Is a revegetation plan required for the scenic easement reserve area to ensure its effectiveness as a vegetative buffer per code
I would
requirements?
say yes.
Boy, we're flying right through here. Does the planning board agree that the additional details should be provided pertaining to the proposed sanitary system for parcel number 2? That was what, 8 for 8? 9 for 9? Tina, thank you very much. McCaffrey, thank you very much. Ed, thank you very much. Okay. Moving on to the sub-waiver review on Adamadeu. Hope I
we're gonna see
pronounced that
Shannon again.
correctly. You got that one also?
Yeah.
Did I mispronounce it? I apologize. Adamadeu, I apologize to the applicant.
Coscositas.
Cositas. How'd we do with that? If I didn't have Ed, saying it before I said it.
Coscositas?
Okay, since you all tried, I'm not going to.
All right, okay. All right. So, do you have anybody else, Ms. McCann? You're the applicant as well? Okay. Engineer, very well. Thank you very much. Okay, go right ahead.
Thank you. Application for 377 Montauk Highway. It's a minor subdivision. The site is shown on the screen. It's located in Wainscott. The original parcel is approximately 270,000 square feet and will be divided into 3 lots, each sized at 84,000 square feet or just over. When easements are excluded. The property is zoned A2 residence, and the minimum lot area in that zone is 84,000 square feet. At the last review of this application in December 2023, the engineer had requested a common driveway plan and had made several, notations about the things that were requested to be shown on the plan. Several items from those comments must still be addressed. The town engineer comment memo is attached, and I think those are pretty clear. They're asking for a depiction of the common driveway and right of utility easement, depiction of drainage tributary areas, adding intersection details, and proposed locations of water meters. And also noting that DOT, New York State DOT approval is also going to be required. Obviously, this is a DOT area of New York 27. So the applicant should review those and provide updated plans to conform to the engineer's requirements. Since the last review, the board has received a public comment, which is included as an attachment to the memo. The public comment is requesting that a scenic easement be mapped between this parcel and the parcels to the east. If the scenic easement was mapped in this way, the area of it would need to be deducted from the lot area of each of the 3 created lots. Meaning that they would be substandard and not meet the minimum lot area requirements. The applicant has proposed, and in previous conversations, the planning board has, been supportive of the currently proposed scenic easement, which would be on the property's frontage with Montauk Highway, as shown here in the in the striped hatch area. This is a more typical placement of scenic easements. They're provided to, buffer and provide natural buffer between the development and public vantage points. So the planning department does recommend that keeping the scenic easement mapped on the frontage of the property is appropriate. We did want to suggest that the planning board consider and the applicant consider whether there are additional mechanisms that could be considered to buffer the driveway from the areas to the east, and whether or not those would be beneficial per the neighbor's request. A slight movement of the driveway westward could potentially accommodate that, especially since the engineering's not complete. I don't know how difficult that would be to accommodate, but that may give the neighbors comfort as well as provide, space for additional plantings, etc. There does seem to be already fencing existing on the boundary between these properties, so that is a boundary that's in place already. With the next section of the memo, we are reminded that this is an unlisted action pursuant to SECRA. We do not have an EAF on file as of yet and recommend that the applicant prepare one also using the EAF mapper, and that once that is received and approved by the board, lead agency status could be requested. In conclusion, the application remains incomplete pending the revised common driveway plan and resolution of whether or not there's any adjustments to the placement of the driveway. Thank you.
Thank you very much, Tina. Ms. McCaffrey.
Hi again. So we've reviewed the memo prepared by the planning department and have the following comments. Regarding the engineering design comments, TF Engineering has made the requested revisions and will submit that revised driveway plan for review by the town engineer. At this point in the review process, we have come a long way working with the board and the planning department to develop a strong map. The applicants have invested a substantial amount of time, energy, and resources into this and do not wish to start over. However, we feel it is important to address the comments from the neighbor to the west and offer what mitigation we can. In their correspondence received by the board on January 24th, Robert and Jennifer Tansman raised three main concerns. They are light and noise from the proposed driveway, potential drainage issues, and a scenic easement. To mitigate the light and noise concerns, we offered the Tansman on February 9th during a meeting at our office a fence along their property line and plantings on their side of the fence. We explained the constraints that we're dealing with and the inability to relocate the driveway, providing them with a scenic easement. The Tansman declined the offer. However, we want the board to know that the offer has been made in good faith and will remain an option until the map is recorded. We think it's also important to note that the scenic easement that exists along the Tansman driveway is an easement that was created in 1991 when the board approved the South Woods at Wainscott subdivision. This easement was intended to protect the existing pitch pines and provide a buffer for the well-established public trail that had run from Montauk Highway to Two Rod Highway at the time, not to protect a private driveway. The easement remains today, but the trail no longer exists as it was displaced by a later subdivision which created the driveway accessing the Tansman property. The planning department questions if we can move the driveway a little west to accommodate plantings. We don't believe that we can. The access easement area must also contain utilities and drainage. We're pitching our driveway to the west to prevent runoff onto the adjacent parcels and situating the drainage along the west edge and placing utilities on the eastern side. David Rhodes from TF Engineering is here to speak to address the drainage and driveway design and also can give an update on the DOT status.
Would you like to speak now?
So I'm just wondering, the neighbors declined the offer of the fence? Is that what you said?
They did.
Plantings and
So
fence?
right now, there's a split rail fence, so we offered if they wanted a 4 to 6 foot stockade fence and then to plant their side so that they wouldn't have to look at a fence, but they did decline that offer, saying that it wouldn't be able to sufficiently mitigate their concerns. They want the easement, not the fence.
And could you describe a little bit more detail what the difference is between what the easement would give them and what you're proposing to give them?
I mean, so they would like us to shift the driveway 20 feet. I'm not fully sure what an additional 20 feet would do because car headlights could travel, I think when I was researching, up to 70 feet outwards. So the best way would be a solid fence because that would stop it at the property line. So I don't know exactly why they don't think that would address their concerns.
Yeah, I mean, scenic easements are typically, heavily vegetated, so the vegetation also provides, a little bit more buffer.
And how long would that scenic easement be? How long would it go
In the
from
map?
north to south?
In the map that they submitted, it started right about here and continued.
So it's almost the entire.
But not.
No, it's not the front, it's not the lot, it's not next to the lot that fronts 27. But after that lot.
2 and 3.
Right, after that, I'm judging by the lines to the east. the property lines to the east. So it's after that, where the cursor is right now, that's where the scenic easement would start
And then,
continue to the, what would that be, the south property line.
And that's,
So whose proposal is that?
yeah, I was going to say, they've proposed that.
that's what we have.
Right, so neighbors have, I think, I think they're very tight with their
Yeah, we are
numbers.
already
I don't-
tight.
No, they are.
Yeah.
And it's kind of starting back, because it starts like all new engineering, all new
Yeah.
survey work, and so.
This has been going on for quite a while, this.
Right, and we've worked very closely with the planning department and the fire marshal to come to this design that we find pretty strong.
So just one more question about this. So they're requesting a 20-foot wide easement from that cursor point south. Is that what they're saying? Or 10 feet or?
It's,
Isn't that black
Hatched
line?
area, yeah. And then they would move the driveway over.
But is that 10 feet or 20 feet wide? I'm just curious.
The hatched area?
Yeah.
They're asking for 20.
for 20.
So there's the 20 from the eastern property line to the driveway or to the end of the hatched line? How far is, well, what is 20 feet?
20 feet west from the property line,
That's,
right?
Yeah, west.
Yeah, isn't that what?
oh, west.
They're on the-
This area is approximately 20 feet wide is what the request
Okay.
is.
That's the hatch, that's the hatch.
That would be a
And then the
significant
driveway.
And
lot
then the
area
driveway would
reduction
begin.
at
Okay.
this point.
Very good.
It is.
But Tina, remind me, so, but even at that 20-foot number, there are issues with lot size at the 20-foot?
Yes, yeah, I
Okay.
mean, the 3 lots right now, I mean, are just making the
just
lot
making it.
area requirements.
So other than that issue, so the way I understood your memo, that the problem with the easement is that it would create a problem with the calculation for the lot size.
Yes.
Yeah,
Yeah.
correct.
So, but I thought that what you were suggesting is to still have that buffer that they want as an easement, but not call it an easement. Was I wrong in interpreting it that way?
So my suggestion was if there were alternate strategies to, address the neighbors' concerns, but not in a scenic easement, right, which is, I think,
So
what-
they would get what they want, it's just, it would not be called an easement.
right.
And the applicant rejected that as well.
Not the applicant, the neighbor.
I'm sorry.
Yeah.
No,
Well, I think,
no,
No.
the
We haven't proposed to
I
shift the
see.
driveway.
applicant doesn't want to do that. Is that what, I just want to
Well, I
understand.
think it makes sense bringing the common driveway up the one property line, keeping it there, and they've already gotten so far with
What about
this.
the buffer that they want?
Well, so we offered to do a fence and to give them additional plantings on their side of the fence.
There's no room on their side, because it's a driveway, to do plantings.
I don't know how we would just have, because then also you would just have like 20 feet of just,
And you'd see,
How many
kind of
feet
have
are
to
we,
like,
how
they
far
can't
off
buffer
are we?
their own
Like, how many
side.
feet
There's no room.
away from the meeting the minimum size? I mean, is it?
we have about 2 square feet.
yeah, they've got like nothing.
it's, yeah.
Like, we don't really have.
And then that brings, then they'd have to get variances for all that,
Okay.
yeah. So that
Okay.
seems like a bigger,
For 2 square feet.
yeah.
Gotcha.
Also, I want to, I'm sorry, just one point that I forgot to mention. Driveways are exempt from
From the
setback
calculation.
requirements and things of that nature. So it's not something that we typically ask for people to provide a setback from the driveway and a property. So I just want to throw that in.
That was,
Yeah, exempt from setback.
May I ask one question? Is the
not part of the
driveway planned to be
calculation.
paved, or is it going
That's
to
a
be?
different-
I will let,
you'll let the-
David, he designed the whole
Got it.
driveway and stuff, but it has proper drainage to make sure
Right.
everything's contained.
why don't we hear from your engineer if
Yeah.
you're going to have him speak now?
Thank you.
Thank you.
My name is David Rhodes. I'm with TF Engineering, and we did do the common driveway. We also did an application to the DOT, which was submitted. I have an email from the DOT that was dated June 29th, 2022, which said that the plans are acceptable. And now they just have to select the contractor, do the perm 33, pay the bond, and they'll issue the permit. So that's not going to happen until the time that they decide they're going to move forward with the construction. So I will give this to Shannon and she can put it in for the record. Your answer to the question is, it is as required by the town of East Hampton. It's oil and rock. That's a standard approach and required on all subdivisions. So it's a bluestone with 2 layers of bluestone with oil. There's also some comments about the drainage to the neighbor's side. There's also, the DOT was concerned about drainage too. They require all their drainage to flow away from the DOT property, so we've done that. It slopes down away from the DOT. We've also super elevated the driveway so it flows from east to west, so there is no flow from the surface of the driveway heading in an easterly direction. Everything flows westerly into a swell and then down into storm drainage dry wells on the west side of the driveway. So there will be no contribution to the east side and the neighbor's property as far as the driveway is concerned. We did review the engineer's comments. We've addressed them. We have a revised plan, which we'll give to Shannon. The only one that we didn't address is the shift of the driveway, which we're already discussing.
Very good. Thank you very much. All right, Ed, shall you lead us in this one?
Yeah, sure. Thanks, everybody, for this. I appreciate it. Yeah, look, I totally sympathize with the neighbors, right? They've been living here for, I don't know, some period of time, I gather, with a town reserve to the north and this undeveloped parcel to the west. And, it's a certain kind of environment that they've become very used to. So, I'm sure anybody in that situation, particularly since their house is quite close to the property line, would feel like, what is this? But having said that, I think it's important to also, remember that there are 2 houses involved here, right? Traffic going to 2 houses because their house is back in the middle lot, right, to Hansman property. So we're really talking about the traffic generated by people coming and going from 2 properties. It's not, it's not a major thoroughfare. It's not even a subdivision street or cul-de-sac. It's 2 houses, right? So we have to kind of bear that in mind too. We've already discussed the fact that making a significant move here or trying to put in a scenic easement would alter the math of this thing, and make it undoable. And, we've been working on this with you guys for a very long time. So that hardly seems like the way to go. And as Tina pointed out, driveways are exempt from setback requirements, right? So I can't believe. So to make an exception in this case to move it in this instance, I think might set a precedent that's really not in anyone's best interest necessarily. I do think the solution that you've offered is to the neighbors is a generous one, and perhaps they'll ultimately take you up on it. But I would sort of say this is the best possible plan under the circumstances, the one we have. Those are my comments.
How do you feel about the EAF? The planning department suggestion?
Yeah, we do. We need one. Yeah. Do we need to declare the agency?
We don't have the EAF yet, so we, yeah.
Okay, all right.
Yeah, for the next
Yeah.
submission.
And the drainage question seems to be adequately handled, by the way, too.
Based on the idea that it flows
To the west.
as opposed to the neighbor's property. Okay, does anyone have anything they want to add on this?
No, I mean, I really tried to take the neighbors' concerns into consideration and see what could possibly be done, but I'm afraid that there's really no good solution. I was happy to hear that the engineer took care of the drainage issue, because to me that was the more important problem, if it was going to be a problem. So that driveway just can't be moved. There's no room.
What about the turnaround? I mean, because I think one of the concerns is perhaps the light, at night, and the turnaround that might be.
I just think it's really minimal.
Yeah,
I
it's one
think it's
house, I
really,
think. Yeah.
again, we have a set plan that they've been working on. We've sort of been, I just think it's minimal.
And we spent a lot of time talking about that.
I wanted to air, no, I wanted to.
Yeah.
Right.
But now that the neighbor has expressed some
I see.
issues, I just wanted to air that on the board.
I don't think the turnaround's ever going to be used. No, I mean, it's a straight shot to the back lot, and depending upon where lot 2,
It's a
they
fire.
You know, it's a
It's
fire.
just a fire. Yeah, it's just a fire requirement.
And it does
so.
have to be at the terminus of the common
Right.
driveway by code.
On the air, so.
Okay.
Oh, very well. All right, should the applicant submit a revised driveway plan?
No. Nope, that was a trick question.
Okay, so that's a no. Should the applicant provide screening between the driveway and the eastern property line?
There's no
They've
room.
offered.
There's no room, I mean.
Yeah.
No, they made an offer of a fence,
Yeah.
and there are many types of fences, so I think more than just one stockade fence. I've seen stockade fence, in between they put a screen or some kind of mesh, and then another stockade fence on the other side to really block the light from the headlights of a car.
I personally don't like stockade fence, so I think that would be
Or-
something that the neighbors, I think, I would let them
yeah.
decide whether they
Right.
want it or
The
not,
offer
you
will
know.
stay in place.
I mean, the country road is much nicer without a stockade fence, in my
Yeah.
opinion.
And with the right, with the right screening that gets planted, and you've offered to plant on their side, it
Maybe after this, you might want to see if there's, some interest in revising on both sides your ideas of what you want to do about screening. All right, should the applicant submit a completed EAF Part 1? Yes. I got a yes on that. Does the applicant agree, well, we're a little premature on that last question, aren't we? Okay. Yeah, I know. We should be doing it. We should have done it at a much earlier stage. All right, well, it's coming, so.
Back again.
Thank you. Thank you very much. Thank you for coming out.
Thanks, Shannon.
Appreciate it. Okay, we're going to move into the regular meeting. So we'll start with ocean surf retaining walls and fence. We have a site plan approval. What you need to do on this is to read in the name of the application, including, most importantly, the Suffolk County tax map number, and then state whether you've read it and what your recommendation is.
So before I do that, I actually just noticed a discrepancy in it, and I probably should have brought this
Well,
up
then, when you
earlier.
make your motion, bring up the correction.
Okay,
And we can amend, we
we
can
can
make the
amend it.
motion to approve as amended.
great. In the matter of the application of ocean surf retaining wall and fence site plan, Suffolk County tax map number 300-501-27.1. This is for site plan approval. I did notice as I mentioned, one discrepancy in the project description A, the proposed site plan, number 7, is referenced as site plan prepared by George Walbridge Surveyors PC, dated last revised January 2, 2024. And then, under the conditions of approval, the approved site plan is a site plan prepared by James P. Walsh Land Surveyor PC, dated last revised January 2nd, 2024. So, just,
Do we know which one is the correct one
It's
on that?
the January 2, 2024 plan.
So that's, well, they're both
They're
dated
both
January
dated
2.
January 2.
It's which surveyor? Is it Walbridge?
Yep.
Walbridge.
Walbridge, okay.
Oh, it's Walbridge, not Walsh.
Walbridge, yes,
That's okay.
yes.
Sorry, Mr. Walsh.
So, I have read this resolution and move for its adoption with the provision that the second, under the conditions of approval, the approved site plan is referenced correctly as prepared by George Walbridge Surveyors.
Is there a second on that revised motion? Second. All those in favor?
Aye.
7-0. Okay. Cool. You're not going to let anything get by. That's great.
I like to edit
I like that. Okay, Sharon. Pinkerton.
In the matter of the application of Pinkerton bathroom site plan, and just want to say that I know I missed this, this,
Well,
is it a hearing?
No.
Discussion?
Discussion.
I know, it's not a hearing, that's zoning word.
Works.
Yeah,
Works.
but I did listen to your discussion, and I agree with the covenant and restrictions that you had decided to put on at the end. Anyways, so the Pinkerton bathroom site plan 300-166-4-1.4, this is to schedule the public hearing. which will take place on March 20th, 2024 at 6:30 PM here, Town Hall, 159 Pentacle Road. And I have read this and move forward with it.
Is there a second?
Second.
All those in favor?
Aye.
Passed 7-0. Back to you, Jen, on Faro Beach.
Faro Beach. In the matter of the application of Faro Beach Incorporated Site Plan, Suffolk County Tax Map Number 300-32-3-14, to schedule a public hearing. I have read the resolution. The public hearing to be scheduled Wednesday, March 20th, 2024 at 6:30 PM, here, 159 Pentago Road at Town Hall. I've read this resolution and move for its adoption.
Is there a second?
Second.
All those in favor? Aye. Passed 7-0.
3 public hearings. Huh?
Yeah, I know.
Wow.
That's why we do them at 6:30. Smart Store. Bruce, that's yours.
Okay, in the matter of the application for an extension of time for Smart Store Site Plan Suffolk County 300-184-1-8.11 by resolution adopted June 5th, 2019, and subsequently modified April 7th, 2021, the resolution, the planning board granted site plan approval to the above-mentioned application, subject to various conditions. Number 2, by letter dated January 29th, 2024, David Kirst, attorney for the applicant, has informed the planning board that additional time is needed within which to obtain a building permit for the remaining phases, and has requested an extension of time. And based on the foregoing, the planning board hereby extends the time within which the applicant must comply with the conditions of the board's resolution for a period of 1 year within which to obtain a building permit, or until April 7th, 2025. In all other aspects, the original resolution of approval has extended is hereby reaffirmed. And I've read the application and suggest we move forward.
Is there a second?
Second.
All those in favor?
Aye.
Passed 7-0. Zone. All right, Bruce, we've got the subdivision modification resolution. You just need to, it's 55 Wainscott Hollow, and then we need to do this. You don't need to read the whole thing through, just the, just the, say that, assuming you've read it.
Yes.
Certainly have.
And this is,
Yeah, here,
Okay.
use this.
I don't have that. Okay. In the matter of application 55 Wainscott Hollow LLC, final subdivision map resolution amending approval, Suffolk County Tax Map Number 300-197-4-2.1, request to modify resolution adopted January 25th, 2017, granting final subdivision approval pursuant to Section 220, subdivision of land, and Section 193, open space preservation of the East Hampton Town Code. The proposed amendment was to clarify the subdivision conditions regarding fences and gates with respect to the building envelope. Requirements 18 and 19 shall be amended as shown with underlying text below. Requirement 18 states no building or structures except fences and gates shall be constructed within 10 feet of an agricultural easement boundary. Requirement 19 states all buildings and structures on the lots shown on the map, excepting driveways, utility lines, fences, and gates, but including all other accessory buildings and structures, shall be confined to the building envelopes shown on the map, where the setbacks required by the zoning code for certain structures, example, swimming pools, tennis courts, necessitate greater setbacks than are shown on the building envelopes. Those greater setbacks shall apply. Anything else I should state here? Modification as approved, to modify the language of requirements 18 and 19 as shown above, which more clearly excludes fences and gates from the building envelopes specified on the approved subdivision map. The reasons to support the modification is granted in recognition that there has been a change in circumstances, specifically at the time of the planning board's original resolution. Ambiguity existed within the town code as to whether or not gates and pillars were to be considered as structures, as defined in section 255-1-20, and whether certain setback regulations and review procedures were to apply to these elements. Evidence of this ambiguity was found within the provisions of the town board resolution, which was Resolution -2018-216 dated March 1st of 2018, which clarified setbacks and procedures associated with those structures and associated these structures as integral parts of fences after the planning board's original resolution. So I read all of this, and I suggest I'm not reading anymore.
You have this one.
I have this one,
Is there
yeah.
a second?
Second.
All those in favor?
Aye.
Passed, 7-0. And finally, the extension of time motion.
Yes. In the matter of the application of Mosswood preliminary subdivision, Suffolk County Tax Map Number 300-157-2-15.3, 16 for an extension of time. I have read the resolution, which the planning board hereby extends the time within which the applicant must comply with the conditions of the board's resolution for a period of 1 year or until April 3rd, 2025. And I move for this resolution's adoption.
Is there a second?
Second.
All those in favor?
Aye.
Passed, 7-0. Finally, can someone who was here at the last meeting, make a motion with respect to the minutes?
So moved.
Does anybody have anything that, actually, does anyone have any corrections or additions or changes to the minutes?
None.
Not for this one.
Now you're on.
So moved.
Is there a second? All those in favor?
Aye.
Very good, okay.
Should I
No, we're doing minutes.
just ask about the minutes for the January 10th?
Yeah, what I was thinking about that is we should probably have them with us.
Okay.
And so if you want to revisit it at the next meeting,
that's totally
talk to Tina, talk to Nancy, and that way you can bring that issue up and we can have it in front of us and be
Perfect.
attached to the packet, and then we can correct the minutes. Okay. You talk about it at the next
Next meeting, you have to come to the next meeting.
I don't
to
like
find out.
secrets.
Stay tuned.
Yeah.
I'll tell you after.
Anticipation. All right, folks. We're going to, in a moment, I'm going to ask for a motion to enter into executive session, but we're going to change council at this stage of the game. You'll recall that at the last meeting we voted, background, on the January 24th meeting, we voted to object to the town's designation as lead agency under SECRA. And subsequent to that, the town attorney advised that that they perceived a conflict, and that the town attorney would not be able to represent the board, the planning board. And so we at the meeting, most recent meeting on February 7th, we voted to retain counsel. That's Scott Middleton of the firm of Campola, Middleton, and McCormick. I apologize. I apologize to Mr. McCormick and Mr. McGoffin, whatever he might be. And we voted to retain counsel, and that, subsequent to that, the town board took up a resolution and indeed retained counsel. So we are now represented with respect to the senior center by our own special, I don't know if you consider it special counsel or our counsel. If I say special counsel, it's just a convenience. In any event, what it does mean is that when we deal with issues involving the senior center, we will be looking to Scott for our advice instead of the town attorney's office and Nancy. So we're going to move into that now, and we're going to, as I say, I'll be asking for a motion to go into executive session. But before that, we've received a request from is it special counsel for the town board?
Special counsel.
You are a special counsel for the town board, who wishes to speak to us regarding the senior center. So again, this is to give an opportunity to speak to us. Plainly, we are not receiving legal advice from the town, from the special counsel to the town board, but we are extending the opportunity to hear from him.
Okay.
Thank you.
Welcome.
I appreciate that. My name is John Armentano. I'm a partner with Farrell Fritz. We are special counsel to the town board with regard to the senior center, specifically with regard to their seeker analysis and the Monroe analysis that was conducted previously. We're here tonight to basically provide you more information. We observed your hearing that occurred earlier last month, where questions were raised. Obviously, you're represented by counsel, but we wanted to at least tell our side of the story, answer any questions you may have, enlighten or provide more information. It's not for you it's really our position. We're not going to be providing you with a determination. You will make that by yourselves under advice of counsel. So we're not giving you legal advice. I'm sure that's crystal clear. But what's before us tonight and what's before you is the town board's request to be lead agency for the senior center. And previously you were sent a letter in early January 19th, which unfortunately didn't include the expanded EAF. So I do understand that the board then adopted a resolution that it passed, which indicated that it objected to the town board serving as lead agency. But from two technical points of view, when there's a lead agency request, when you are coordinating a review, which we are because this is a type 1 action, it's elevated to a type 1 action because of the property's location next to the town park. So under normal circumstances, the area that's going to be cleared would be considered an unlisted action, which would not have required a coordinated review. But it has been elevated to a type 1 action because of the location of the town park, which diminishes the amount, and I don't get into the weeds with this, but because it diminishes the amount of clearing that can be considered an unlisted action. So that's why we are required to conduct a coordinated review. Based on information that was not sent to you, the town board then sent a new request to serve as lead agency with the 70-page expanded EAF, which included a traffic analysis. So the one corner, it's maybe a housekeeping issue, but council will advise you, your letter of January indicating your objection to lead agency, under the requirements of seeker, lead agency has, when there is a request for lead agency, unless it is consented to, and it has been consented to by the ARB and the ZBA, but if you object to lead agency status, you also have to indicate your intent to serve as lead agency. So that wasn't really clear in your letter, and that's an issue that we would consider to be, I think you could say was the functional equivalent of seeking lead agency, but for clarifying purposes, you may want to qualify that. And I also believe that the reissuance of the EAF with the expanded EAF is now properly before you, where you can make your determination as to whether or not you're going to contest lead agency or consent to the town board being lead agency. And a lead agency, as you're aware, is an agency that has the authority, the approval, the funding, and in this case, the town board has all of those criteria. They also own the land. This has been a project that has been considered extensively by the town board. But that's a determination for you to make. Lead agencies have the more of the parts of the review process than the other involved agencies. Now, there's no question that you're an involved agency under your site plan review authority. And we're at the very early stages of this process, but the most important part is you have to have within 30 days of the coordinated review, you have to have a lead agency so that the project can go forward with secret determination, which is the first part of any project. As I'm sure you all know, you've been doing this for a while, you understand secret, I'm sure. But so the issue then becomes, when the lead agency is declared or agreed upon, and this is not adversarial, I'm just giving the town board's position on these conditions, but that the planning board is an involved agency, and before a lead agency can make a determination, it has to seek the input of the involved agencies. And in meeting with the town board, and you may or may not be aware of this, but the town board is scheduling presentations of this project before each of the boards, the ARB, the zoning board, and the planning board, so that you will see the project in its form that the town board would like to go forward with. So you'll be able to see it as an involved agency if you choose, and provide input and comments to the town board, which will hopefully be the lead agency. But that's the process if it goes in that direction. So you're involved in the project, and before a determination can be made, the lead agency seeks input from this board, so you're involved in the process. But the question then comes up, if there's an objection as to lead agency, that determination is then appealed to the commissioner of the DEC, and he makes the determination, and there are 3 criteria for that. And I can just read them to you briefly, just so you understand the process, and that's done by a petition or an appeal to the commissioner, which within 30 days, and then each side presents its information. And the criteria that the commissioner considers is whether the anticipated impacts are primarily of statewide or regional significance. So that's not the situation. The second is which agency has the broadest governmental powers to investigate the impacts of the proposed action. So that's really where each party's jurisdiction kind of springs from, and that's one of the factors that the commissioner weighs. And then the third criteria is which agency has the greatest capability to provide the most thorough environmental assessment of the proposed action. And that's another factor that the commissioner weighs. And in this situation, the town board has retained special counsel for these purposes. They retain environmental consultants, L.K. McLean, which does a lot of work for the town, and they've done I believe, a tremendous job in analyzing this project. They also provided the traffic information, and the town board has also hired an architectural review board. So the town board has access, as you do, to the planning department, and the planning department provides guidance on these items as well. So boards are equally served, but the town board has contracted with other experts to further understand and explain the project to them. So I'm not going to weigh the factors for you, but that's what the commissioner would weigh. And these contested lead agencies are not that common. It's really, I hate to say, usually all agencies get along, and there's comity among the boards, and there's an understanding as to working together through the process. So they're not that common. And the majority of these, and these decisions are online, discusses mostly the conflicts between counties and towns, towns and villages, water districts and towns. It's really not, there aren't many decisions that weigh intergovernmental agency issues, but there were 2 that dealt with the town planning board and a town board, in particular dealing with site plans. And these 2 cases were one's in Albany and one's in Putnam. And it's the town of Southeast Planning Board versus the town of Town East, the town board. And in both circumstances, I can present these to your council, or I'm sure you can research them as well, but I can provide them for you. The commissioner made a determination that the town board was the correct lead agency because of their involvement in the process and the greater jurisdiction is what they called it, and also the ability to have studied and to also have the primary function to approve the project. And in this case, as I'm sure you're aware, this is town land, it is a town project. The town board is going to consider and approve a form of this project. So the town board has a lot of control over the project. So that's a factor that I'm just telling you the process as to how this would go forward. That was weighed in these 2 cases, and there are very limited interagency conflicts. And in these 2 circumstances, the town board was found to be the agency to be awarded lead agency. So that's kind of the big picture and kind of the process. I'm sure your council will advise you of the same, but I just want to give you that information so you can deliberate on that. I can answer any questions you may have. I also know that there's a Monroe aspect to this. The Monroe is separate and distinct from the seeker issue, but we have been directed by the town board to draft an analysis of the Monroe hearing, which basically weighs the public benefit of the project versus the issues of zoning. And zoning is permitted to have zoning immunity or limited immunity for projects. In this case, we believe has that criteria. But as part of that process, it's not just a complete usurping of your authority. We don't want to have, and I don't know if the mixed messages or somehow that may not have been communicated, or there's some concern about a turf issue, or I don't know how else you would call it, but, a jurisdictional question, which board is more impartial, which board would make a better determining factor or weigh everything appropriately. I mean, I know you do site plans all the time, I understand that. But part of our direction from the town board was to draft the resolution so that the town board will seek limited zoning immunity, but seek the advice and input from the ARB with respect to their areas of expertise, the zoning board, and the planning board. So I wanted to make sure that this board is aware that the Monroe resolution that we are drafting for adoption or not by the board, and it can be modified, but the one that we've been directed to draft has that provision where it's not, sometimes Monroe was done where the one board is now immune from any other boards. You can modify that, and the town board has directed us to do that so that this board is involved in the process because they want you involved in the process. I mean, that's what I have been told, and that is what has been delegated to us to articulate to you tonight and to also put in the resolution from in the Monroe analysis. So I think you look at them together. I don't want anyone to be misled that the town board is seeking to do away with your ability to comment on the project, make comments, and they will be considered. And you have the planning staff as well, which will be also making their own comments to the project. So I just want to be clear. I want to make sure we get a full picture of everything that's involved, the process, how it works. If you have any questions for me, I'm happy to answer them. If you don't, I mean, we'll...
Let me just defer. Is it appropriate for us to be asking council questions?
Well, I mean, it's not that it's inappropriate, but if it boils down to a Q&A, I don't know. I mean, they've presented their side and how they propose to analyze this and move forward with it. So, it's up to the board.
If it's a factual question, I can answer it if you feel appropriate.
I would, if it's a factual...
Right, I don't think, it can't boil down to...
It can't be a process question.
Advice.
Mine is a process question, so maybe I'll save it for
hold
our
off
council.
till where would council. All right. In that case, thank you very much. We appreciate you coming out, and we're glad to have heard from you.
Thank you.
Thank you so much.
Now, I'm going to ask for a motion to enter into executive session. I have a question. They're going to go, and this is LTV. Matt, you listening?
I am.
We're going to go into, assuming that the motion passes to move into executive session, we'll move into executive, so that has to be a vote. We'll move into executive session. Our staff, what shall Ms. Jody do?
Well, the staff should all leave. The purpose of the executive session is for me to be able to discuss with you things that would be subject to attorney-client privilege. So that's the basis for moving into the executive session.
But following the executive session, there may or may not be a resolution.
Correct. We come out of executive session, go back into the regular session, and if there was a determination made during the executive session, it would have to be placed on the record, or you could ask for a vote when you come out, whichever way.
But in terms of staff, we need to ask staff to wait in the other room. Is that the idea?
Yeah, and we'll be as quick as we can.
Sorry. Nancy, Tina, thank you all very much. Oh, actually, hold on, before we do that, I ask for a motion to enter into executive session to discuss matters made confidential by state law concerning the receipt of legal advice from our counsel, which is subject to attorney-client privilege. Can someone make a motion on that?
Moved.
Is there a second?
Second.
All those in favor of moving into executive session?
Aye.
Passes 7-0. We are now, Matt, we're in executive session.
Stand by.
You're gonna put the seal up, right?
There we go.
Hey, can you hear us? soon as they come in, okay.
As soon as Jody takes her seat.
Gotcha. Gotcha.
Okay, planning board, we're back up.
Very good. Okay, as soon as Jody gets to the perch of influence, we will. Oh, you know what? We also had the January 19th letter that we objected to previously and refused to withdraw that objection.
I don't think that's necessary, because I think it's a nullity, because what you were objecting to was really...
It's been subsumed, superseded, to use a lawyer
by
word.
the February 5th letter, so.
Yeah, so, well, but we do have that vote on the record. Should we take a vote to now withdraw that
First, you need
previous
to make a
letter?
motion to come out of executive session.
Thank you.
And then you can vote on what was discussed in executive.
Very good. Okay. All right. I make a motion that we come out of executive session.
Second.
All those in favor?
Aye.
Passed, 7-0. I'm going to make a motion that we withdraw our January 25th letter. Is there a second on that?
Second.
All those in favor of withdrawing our January 25th letter?
Aye.
7, well, you're going to abstain because...
Abstain. I like that.
6-0 with 1 abstention. And now, I move that the planning board send a letter to the town board or community, withdrawn. I move that the planning board respond to the February 5th, 2024 letter from the planning director regarding the proposed Town of East Hampton Senior Center, and that we advise the town of our objection to the town declaring itself lead agency for the project and indicating the planning board's intent to declare itself lead agency for the project. Is there a second?
Second.
All those in favor?
Aye.
All those opposed?
Aye. Me.
No, you say nay.
Nay.
If you're opposed. 5-2, passed. I now would like to entertain a motion to adjourn.
Right, I'll second that, yeah.
I'll second.